by some appointments which do not fulfill the Bangalore criteria. In my view, the judiciary has to be conscious of its independence, but before I come to the collegiate system, I need to begin with reference to a case which is a case of its own kind. As you are aware, that after the emergency was imposed, orders of preventive detention were challenged in the various high courts in this country. The judges, with fearlessness, quashed these orders of detention as a fraud on the Constitution. It is sad to say that 16 judges of various high courts were transferred, and purportedly with the consent of the Chief Justice of India. One of the judges, who was transferred from Gujarat to Andhra Pradesh, was a person called Mr. Sakulchand Seth. Mr. Sakulchand Seth, after his retirement, practiced as a senior advocate in the Supreme Court, happened to be a great Gandhian. He always took the bus to go back to his house. He carried his own papers, was meticulous in his preparation, and was an outstanding lawyer. Mr. Justice Sakulchand Seth filed a writ petition, and he challenged the order of transfer. It was listed before 3 judges of the Gujarat High Court. The 3 judges struck down the order of transfer. But it is important to note the extent to which the Union of India or an executive government can go in asserting its authority over the judiciary. The Union of India was represented in Gujarat by an additional Solicitor General, and the additional Solicitor General urged that the 3 judges who were hearing the case must recuse themselves because there was a possibility of their being biased against the Union of India. The judges inquired of the additional Solicitor General that what was the basis of alleging bias against them. He said that your lordships have been in correspondence with the Chief Justice of India. The judges retorted, we are prepared to give you copies of those letters, but if the Chief Justice of India wishes, he can produce them. And the additional Solicitor General did not appear on the next occasion, but the objection of bias was insisted. The full bench quashed the order, and the Union of India filed an appeal. It must be said to the credit of the then Attorney General, Mr. S.V. Gupta, whom I had a great privilege of knowing and appearing with him as his junior in a few cases, was a man of great rectitude. As an Attorney General, he said that he did not find any justification for the transfer and that the government was being advised to retransfer Justice Sheth to the Gujarat High Court, and upon that statement, Mr. Sheth took leave of the court to withdraw the writ petition. But since the issues were of some importance, the Supreme Court went into this matter. And I'm sorry to say that this judgment has certain very important aspects which have been overlooked. The first is, the Supreme Court took the position that consent was not essential for transfer of a judge. In my view, a judge who occupies a constitutional office under the Constitution has to be treated with respect. To transfer him from one high court to another against his consent is a form of intrusion into the dignity of the office. In my view, all the judges were in error in assuming that consent was not consistent with the independence of the judiciary. However, their lordship said that independence of the judiciary was important. So they said that there must be effective consultation with the Chief Justice of India. But what is important to note is, they said that if there is no effective consultation with the Chief Justice of India, a writ petition under Article 226 would lie, which means that judges who wish to challenge their orders of transfer would need to file writ petitions under Article 226 to question those orders. I find it somewhat disturbing. But the most important aspect of this judgment, which came to be practiced as a convention, was the transfer of judges under what is called considerations of public interest. I have been unable to understand that what is this public interest which is meant to be spoken about when you deal with judges of the High Court. I am of the firm opinion that if public interest means that a judge and his conduct is unbecoming of that office and he must be transferred to another High Court, it is utterly unfair to any bar or to any segment of the population in this country that they must be visited with a defaulting judge by way of transfer. Transfer is not intended to be a mechanism for correction of an errant or an aberrant judge at all. The suggestion that the power of transfer must be exercised in public interest was indeed, in my view, a direct dilution of the principle of independence of the judiciary. Therefore, I wish to say that the judgment of the Supreme Court, even though it held that independence of the judiciary was a basic feature of the Constitution, yet by denying the judge the right even to consent, by denying the judge even to be heard, and above all to say that public interest can be a ground for transfer, was a direct dilution of the independence of the judiciary. I hope one day this judgment will be overruled. The next judgment which I wish to refer to is the judgment in S.P. Gupta's case. It is extraordinary, and we are talking about a claim for equal stakes in the say of appointment of judges. The law minister had written a letter in 1980s saying that judges should be transferable and they can be transferred from one court to another. In my view, this entire idea of transfer of judges is pernicious and is contrary to the spirit of the Constitution. The transfer provision under Article 222 was only meant as an enabling provision in certain situations. It was never intended to mean that a judge who quashed an order of detention could be transferred from Delhi to Sikkim. It was never intended to mean that a judge who concurred with the main judgment would be reverted from the post of a High Court judge to that of a Sessions judge. Therefore, I am of the firm opinion that the attempt on the part of the executive, under the guise of claiming and demanding accountability and to impart a certain kind of democratic pedigree to the process of judicial appointments, must not be permitted an encroachment. But in Gupta's case, let us go further. The question was that what is meant by consultation? And I say with great respect, the majority opinion in Gupta's case was again a second blow to the independence of the judiciary. For a court to say that great weight may be attached to the opinion of the Chief Justice of India, but ultimately the appointing authority is the central government, was indeed a very poor reflection on what was intended by the Constitution. While it is true that the draft Article 103, which was proposed on the basis of what was suggested by the committee of judges consisting of Federal Court and High Court judges, who suggested that recommendation of a Chief Justice must be mandatory, but yet the judges converted the question whether consultation meant concurrence. The question is not one of concurrence. The question is who should have a say in the appointment of judges? Who are the persons who are best qualified to actually suggest the names of appointment as judges? It is in some sense true that it is the judiciary and Later it was felt in the Advocates on Record case that a collective opinion of the judiciary, that is the view of the judiciary, must be seen as determinative of who should be appointed. Yet the executive was always given the freedom and discretion to point out any feature of unsuitability insofar as a judge's credentials was concerned, in which event the judgment prescribed a process for further consultation. I must say, with great regret, that the records will bear out some very startling features. In my view, the process of appointments has definitely caused some concern to eminent members of the bar. We have often seen that some of the most outstanding judges in the High Court have not been appointed to the Supreme Court. But can there be something called legitimate expectation in a judge's life? In my humble submission, the judgment on this issue in the Advocates on Record case is again destructive of the independence of the judiciary. To introduce elements of ambition in judges, and that to judges of the High Court, is not correct. It is one thing to say that fairness must prevail in the appointment process, but it is entirely different to say that seniority is a relevant factor for the purpose of considering a person to appointment in the Supreme Court. I think that this requires revisitation. But most importantly, what needs to be considered is that the criticisms against the collegium have to be addressed by the collegium itself. What are those criticisms? The first, do personal antipathies influence the final selection of candidates? There is some evidence to suggest it does. It is important that this impression is corrected. Second, that certain candidates who have absolutely nothing against them, who are outstanding, are still overlooked for appointment to the highest court. This needs some amount of explanation. But lastly, and that is my biggest criticism, is that the methodology of consideration is inadequate. While Justice Hidayatullah and Justice Sikri have both said that they looked at the judgments which were delivered by a judge in his court as a basis for consideration, the criteria, which is namely the Bangalore principles, must be viewed as objective criteria on the basis of which each judge must look for material and discern that material not on the basis of second-hand or tertiary information, namely what appears in a rag or in a column, but which depends upon a certain personal verification. If careful appointments have to be made, verification by those who are in the collegium is necessary. In some cases, they may even have to have a personal interaction if the person is going to hold the office as a Chief Justice of India, to make sure that the candidates who are appointed will hold that office with a certain degree of maturity and with adorn the values which are enshrined in the Constitution. That brings me to the question, the Judicial Commission. In my view, the first opportunity must be given to the collegium to correct its processes, bring into existence the Bangalore criteria, and use that as a benchmark, and also give liberty to discard the principle of seniority and look at what is fundamentally required for the court, its integrity, its dignity, and above all, its ability to dispense justice freely and fearlessly. It is of great importance that we have a system which is free from executive influence. Even though the Chancellor did not interfere with the process of judicial appointments, Britain celebrated its separation of powers only when the Supreme Court of the United Kingdom was set up, and by virtue of international conventions, there was a commission by which judges could be appointed. But we must understand that commissions which exist in the United Kingdom, in South Africa, and in other jurisdictions must not be automatically imported into India. Now let us look at what has been attempted. The idea of a commission has been borrowed. It is said that the commission which was proposed by Justice Venkatachalaya in the Commission to Review the Working of the Constitution also recommended a judicial commission. But when you look at the composition of the commission, you find that it is the Chief Justice of India. There are 2 senior judges, which makes it 3 from the judiciary. The 4th person is the law minister. Now it is one thing that a lawyer may be a law minister, but what happens that if a politician who has never even studied the Constitution becomes a law minister? And that possibility is not very remote. And if he were to be one of the members of this commission to appoint judges to the highest court of this country, I think it is a matter of some concern. But now let us go beyond 4. We have what are called eminent jurists. I'm afraid many people would like to be called eminent jurists. The number of persons who wish to be called eminent jurists may be much larger than the number of aspirants for offices as judges. So, if 2 eminent jurists have to be selected, and again, the selection will be done by 2 out of 3 people being again from the non-judicial elements. One is the Prime Minister, the other is the Leader of the Opposition, and the third is the Chief Justice himself. So in some sense, the Chief Justice will sign a decimation of the independence of the judiciary, because he would be definitely outvoted even if he disagreed with the names of the jurists who should be on such a commission. The result would be that you may have what is called the National Judicial Commission, but it would be a commission which has been commissioned to nationally undo the judiciary. And I think it is something which needs serious reflection. In my view, this idea of wanting to take over the process of appointments is a way to send a message that the judiciary must always work harmoniously with the executive. I'm afraid this expression